Hi everyone, thank you for joining ABCC on our first online webinar. So today's session is on busting myths about furlough and planning for the future. Our agenda today is, so my name's Anjum Khan, I'm the Director of the Asian Business Chamber of Commerce, and today we have Neelam Afzal, who's the Employee Solicitor at Wildings Solicitors, and Omar Rashid, Director from the HR Department. This session will explore busting your myths about furloughing your workforce, key information on furlough, leave, and planning for the future of your business's workforce and remote working. We will be doing a Q&A at the end of the session, so please do type any questions you have in the chat on the right-hand side of your screen. Just before I introduce the speakers today, just to let you know, as the Chamber of Commerce, we are here to connect, support and grow, help all businesses. So if you are not a member and you are interested, you are able to contact us to find out about other upcoming webinars that we have. You should be able to see a slide right now, and you can go on to www.greaterbirminghamchambers.com and view all events for April and May, and it is quite simple to book onto these events. So I'd like to now welcome Omar Rashid from the HR department.
Thank you, Anjum. Welcome everyone. So I'm sure you've heard a lot about furlough over the last couple of weeks. I'm just going to give you a whistle-top tour really today. So if there's any further questions, then obviously please do reach out and ask. So furlough, just very quickly, which businesses are eligible? So ultimately all businesses in the UK are eligible. That includes charities, that includes recruitment agencies. The only slight exemption you could say are public services, public sector services, where the expectation is that they will continue to provide and the work will be there. The criteria set out, as we know, is that you must have a PAYE payroll scheme set up as of the 28th of February, enrolled for PAYE online, have a UK bank account. And initially, this scheme, the furlough scheme, is set up for 3 months going back from the 1st of March. The government have said that they will review and it may be extended, but that obviously depends on how things develop with COVID-19. So which employees are eligible? So again, the key date is that they have to be on your payroll as of the 28th of February. And those include that may have been placed on unpaid leave, because this government furlough didn't come about until the 20th, around the 20th of March. If before furlough was introduced, this scheme was introduced, if you made staff that were made redundant or they'd left, you do have the option to rehire them and place them back on furlough as well. And other employees that are eligible, those that are on agency contracts, flexible or 0-hour working, salary directors, office holders, key individual workers such as nannies, cleaners, apprenticeship salaried partners, and people on fixed-term contracts as well. So I'm now just going to kind of go through some of the myths or some of the FAQs that have been floated around, been asked around over the last couple of weeks, just to kind of put or offer you some clarification as well. So most common question we get asked is, can I just place my employees on furlough? The key thing to remember is that you must obtain their consent, as it is fundamentally a change in their terms and conditions. So have an agreement set up, have that signed and agreed, outlining what the terms of furlough is. Please don't use Google or any sort of templates that are out there. Try and get these agreements from a HR professional or an employment lawyer. Get those sort of checked before you issue them to staff. Do I have to top up the 80% grant? So as we know, with furlough, you're only going to get 80% back. The government will fund 80% back. You can top up the 80% to pay the 100% salary, but it isn't mandatory for you to do so. So again, it makes it more important that if you're not going to top up, to make sure you get that consent from your employee. Can I employ someone now and furlough them? So the answer is no. They have to be on your payroll as of the 28th of February. That is a key requirement from the scheme and the guidance that has been set out. Can I give my employees a pay rise and then reclaim? So again, part of the guidance is if someone was to have a annual salary review increase in March or April, unfortunately, it is what would be reclaimed as at the 28th of February. So just to bear that in mind as well. Okay. My employees can't refuse to be furloughed as it is my decision. So there's a bit of a misconception, actually. Employees can refuse to be furloughed, and this is why you must get their consent. If they refuse to furlough, then obviously you may need to explore other options, some being unpaid leave, some may be layoff if you've got that in your contracts, or ultimately then you'll be looking to make them redundant if the work isn't there. My employees off sick or shielding, so they will only get SSP. You can now claim furlough for them, but you can't claim furlough and SSP for the same time period. So you need to then ascertain which time period that they were off sick and SSP to the which date you've then made them furlough. Okay, another common question asked is, so I have an employee, an administrator, they work 5 days a week, but due to the downturn in work, I only need them to work for a couple of days. Can I then furlough them for the remaining 3 days? Unfortunately, no. So if they are furloughed, then they just cannot do no work with you at all. So just bear that in mind. If it is a situation as this, then it will be looking at reduced pay, and again looking to get that agreement with them as well. Okay, my employee can't be furloughed by me and then work elsewhere. Well, actually they can. So recent guidance has come out. So there's two ways. One, they could already have 2 separate jobs, so they can be furloughed by you and still continue to work with their other employer as well. The thing to bear in mind is obviously with the furlough, with yourselves, they get 80% or 2,500 per month capped, and it works both ways. So it isn't like that they've got 2 jobs and then it's separated or it's combined with both. It's actually 2 separate situations. So if they've already got 2 jobs, yes, they can be furloughed in one and carry on working in the other. If they're still if the only job is with yourself, if the contract permits or with your consent, they can go and work elsewhere as well. So ultimately, they could be in a situation where they are earning 180% of a salary. So that's 80% furloughed and then a new salary with a new employer. Okay. I can ask my employee to do some work if needed whilst on furlough. So as I reiterated, that is not the case. They cannot do any work. They literally are sort of like shutting up shop. If you do need them to do some work, then ultimately they will be off furlough. So if work comes in, requirements needed, you can take them off furlough. Then you pay them as normal, and then you can then put them back on furlough again. So they can be put on furlough on multiple occasions. I only need to furlough my employee for a couple of weeks. Is that okay? So the minimum requirement is for them to be furloughed for 3 weeks. So again, if you look at the question above, if work comes in and they've been furloughed for less than 3 weeks, then you would have to then pay them the normal salary. So just bear that in mind that it is a minimum of 3 weeks that they need to be furloughed. Can I make my employee redundant after furlough if business does not pick up? Yes, you can. Obviously, exhaust alternative options such as redeployment or maybe laying them off for an extended period of time if your contract allows you to do. But ultimately, yes, there is still, if there is the situation of making them redundant, you can do so. My employees at home looking after their children, I guess that is annual leave or unpaid leave as they cannot work. Well, now the recent guidance has come out that employees with caring responsibilities, such as looking after the children, can be furloughed as well. Okay, my employees can't even do training courses. Yes, they can. They can do training and they need to be paid minimum national living wage or national minimum wage, and this will be separate to their furlough salary as well. So that's something that you would have to then treat and pay separately. I am the sole director and on PAYE, I can furlough myself and still respond to general queries. So this is a sort of a common question that we get asked. Ultimately, you can furlough yourself, but you have to make sure that you are not doing any work that makes money or provides services for your organization. So even if it's posting on social media, advertising, if you're doing an mail shot to clients or prospective clients whilst you're on furlough or you're deemed on furlough, that wouldn't be acceptable. So if you are a sole director thinking about making yourself furlough, then you really do, again, have to think about making sure that you are doing no work at all, minimum amount of work for 3 weeks. At the moment, we don't even know how dive the HMRC will audit. So again, always on the caution if this is something that you want to look into. And there are other alternatives for self-employed as well. There are options, again, 80% of your earnings over the last 3 years, up to, if you've earned up to £50,000 a year profits. So there are supports out there. So again, just bear that in mind as well. Okay. I can furlough my employees and then pay them when I receive the grant. So it kind of depends. And the best example is to kind of give you what's going to be upcoming now. So if your April payroll normally is going to be paid on the 30th of April, you can actually apply for the grant on Monday, the 20th, and then you receive the grant in time to make those payments. If you've got a situation where you paid them weekly, you might be expected then to pay that on a weekly occurrence and then make a claim. This is, again, something that you need to bear in mind. If it's not something that you're able to do, again, gain consent from your employees around that you'll be getting paid once you receive the grant as well. Okay, I can't sack my employee whilst on furlough. So just remember, whilst they're on furlough, they are still your employee. They still accrue annual leave, all the statutory procedures, statutory pays as well. So equally, you can, if needs be, if you need to dismiss them, you can. Prime example, if they start posting on social media, that may be something that's inappropriate, that's against your policies and procedures. Follow the correct procedures, and again, you can, if need be, sack your employee. If furlough continues for an extended period of time, will employees lose their annual leave? No, the guidance has come out that you can carry over 4 weeks, and that can be spaced over a couple of years as well. And this will be something that I'm sure Neelam will be expanding on. So what happens next, just to kind of summarize? So the HMRC portal will be launched on the 20th of April. Expect further guidance. There's been some guidance around what to kind of get ready, what to submit. So speak to your accountant, speak to your in-house payroll, speak to whoever actions your payroll to have that information ready. They're hoping that the payments will be made to you by the 30th of April. The term is used that this is a grant, so at this moment in time, we assume that there's no requirement to pay that back. It now includes past overtime, compulsory commission, and fees that you can claim for as well. And you can claim once every 3 weeks. So it's not a regular occurrence, not a weekly occurrence that you need to do. You need to claim for the pay period every 3 weeks. So this is sort of some of the information that you will require. And I know there is some guidance coming out for some further information as well. But again, your accountant, whoever does your payroll, will be able to advise you further as well. Okay, so that's my part of the information of the webinar. So if I now hand over to Neelam, and if there's any questions afterwards, I'm happy to answer them. Thank you.
Thank you, Omar. Over to you, Neelam.
Afternoon, everyone. I'm going to be talking about future planning. So once the furlough leave period is over and we're all back at work, I'm going to give some quick tips on what we should do as a business to ensure that if future problems arise, what we should be implementing in our contracts and our handbooks. So first of all, to start off with, I would recommend that people look at their contracts of employment and have a look at whether they've got layoff clauses and short-time working clauses. Now, often in businesses such as factories, shop floor workers, they will all have these contracts about layoff, clauses about layoff and short-time working. but most businesses won't have them. So a recommendation is to have a particular clause in your contract. Now, if you don't have those clauses in your contracts, I would recommend that you consult with the individual employee, the union rep or an employee rep to put these clauses into your contracts when we return back to work. So in terms of layoffs, so layoff is where an employer temporarily shuts its operation because it can't find any work or enough work for its employees to do. So for example, and I've put some examples there where there could be depleted order books, problems with supply chains of raw material, or because the employee is temporarily, because there is temporary less work available for staff. So short-time working is where there is a partial layoff, where there's a diminution in work. So basically, short-term working is where there is a reduction in the number of hours somebody works, and thus a reduction in the number of in their wages. So a typical example of a short-time working is where somebody is working, let's say, 5 days, and they've now reduced down to 3 days or 4 days. If it's not in the contract, it is really important that it is agreed by consultation and put into the contracts. Because if an employer just unilaterally imposes that right of short-time working or layoffs, an employee can suggest that actually there's a breach of contract and resign and potentially bring a claim for constructive dismissal or redundancy. So it's very important that those clauses are in there and they've been agreed with the employee. There are also fixed amounts and periods of time. So for example, with layoff, you can claim the employee is entitled to be paid. It's a very nominal amount, £30 per day, and it's for a maximum of £150. And it's 5 days in any 3-month period. Now, after a certain period, so 4 weeks or more in a row, or 6 weeks or more in a 13-week period, the employee is entitled to request redundancy if it appears that the request is going to carry, if they're going to be in layoff or short-term working for longer periods. Now, one of the things that we've seen is a lot of businesses have had to gear up to work from home. And I expect that what will happen is when we return back to work again, there will be significant requests from employees, a rise in numbers of employees requesting for flexible working. And businesses have already seen the benefit of flexible working. For example, reducing overheads, working from home means that individuals can work around without having to be present in the business. So an employee can make a flexible working request, and that's to change how many hours they work. They can change the request, how that work is done, and where that work is done from. So flexible working requests, they're primarily a statutory right. So it's a legal right that the employee has to make an application, and there is a right on the employer to process it properly. The employer doesn't have to change the terms and conditions. It's a case of the employee making an application and the employer going through a proper process to ensure that they've considered the request and the reasons as to why that request has been accepted or declined. So I'm just going to run through the criteria in relation to who can make the request. So it has to be an employee, and they've got to have at least 26 weeks of continuous service, and they can only make the application once in every 12 months. And like I said, the types of requests could be to change the hours, to change the times they work, to allow more flexibility, and to change the location. I expect that we'll see applications to change where somebody works from. There are other considerations like job sharing, becoming part-time. So the application, and it's important that businesses recognise that application. For example, a letter from an employee may contain these items. So the letter or the application has got to include the following: so that they're requesting for flexible working, They need to specify the change that they would like to make, the date that they would like that make that change happen from, explain what the effect of that change is and how it could be dealt with. It's made in writing, and it's also then dated. So the employer is obliged to deal with that application in a reasonable manner. It's within a time period that it has to be dealt with. So it's 3 months from the date of the request, unless it's extended or agreed. And the employer needs to consider, meet with the employee and consider whether this will work for their business and whether there's a legitimate reason to decline the request. So I've just set out there the time periods. There's no right of appeal. So if the employer decides to decline the request for flexible work, there's no legal right of appeal, no statutory right. However, it's good practice to include that appeal process in there. And there are some of the reasons. Now, each case is fact sensitive. So every case and every business will differ. So it's important to look at what works in your business and whether you can accept the request, and also the reasons why you would decline that request. And there are some of the reasons: extra costs that will damage the business. The work can't be reorganized amongst some of the staff because some of the work has to be done potentially in an office or in a factory setting or a retail food setting. So the other requests are, for example, the reasons to decline are it may affect the quality and performance. Business may not be able to meet the customer demands. There's a lack of work to do within the proposed working hours, and that there is business planning, which means that there's changes to the workforce. So each case is looked on a case-by-case basis. Now, whilst I've talked about looking at your contracts, so looking at short-term working, layoff clauses, looking at flexible requests, there's a whole raft of policies as a business that you need to look at when you're going back to work. If you've got them in place, look at updating them. Given the current situation, the pandemic that we've had, a lot of policies fall short in relation to flexible working requests, layoff short-term working policies. I've not touched on redundancy, which is a whole area, because we expect that when businesses do go back, there will be some reorganization, restructuring that will happen. Look at home working policies and remote working policies. Look at risk assessments when you're working from home, lone working policies, and data protection. There are some data protection implications when you are working from home if you're taking away data, your PC, and how you're holding and storing that data as well. So that's a really quick overview at this present time about what you should be considering when you return back to work as a business, and some of the key points that you may want to look at implementing in your business going forward. Thank you.
Thank you, Neelam. I'm hoping that Omar will be also joining. If I can just ask you both to be muted. We have had several questions come through, and I will try and cover as many as I can do. The first one is there any guidance on furloughed employees' use of social media? Sorry, can I just ask you both to put yourselves on mute while I just read out the questions? Thank you. Is there any guidance on furloughed employees' use of social media whilst they're on furlough, so as to avoid being seen as doing work? So if one of you could go ahead and answer that question, please.
Okay, well, I mean, what the guidance suggested was that the employee can't be looking to make any profit for the business. As long as they're not making profit, as long as they're not generating income for the business, and proactively bringing work in, using social media to put out a post about a particular issue, viewpoint, I can't see any issue with that. I don't know if Omar's got any more to add to that.
Yeah, I think the key is, like you said, it's not a post not seen as generating leads or generating interest to your business. A generic post, just, you know, what you ate or whatever, would obviously suffice. Thank
you both. Next question. Sorry, Omar, can I just ask you to put yourself on mute?
Sorry.
That's okay. Next question. Do you know how HMRC will monitor whether employees are following the rules and what the sanctions are for not doing so?
Okay, I'll go for, I think the worst case, not the worst case, the most severe sanction is a criminal sanction of fraud, ultimately. That would be the worst case. I think at the moment we're in unprecedented times. We know that HMRC will do a form of auditing. How, like I said before, how deep that is, how much that goes into. I don't think there's actual, other than what's sort of stated, other than what's, what you're required to submit when you're making a claim. So, your sort of your tax reference numbers, your UTI numbers. Other than those sort of details, I don't think there's any other actual guidance at this moment in time. I don't know if Neelam wants to add to that as well.
What I would say is that they have said that there's a recoupment provision. So if they do make the payment, they'll look to recoup the money back that they've paid in relation to that individual. The other issue here is about directors, and there's a duty, director's duty as well, to ensure that they don't commit act of fraud. So there's potentially to be struck off. There's potential, like Omar said, criminal proceedings that could arise. And I expect, although we haven't seen it at the moment and there's no guidance, but I would think that if this if it does happen, there may be potential for fines, but that's not been suggested at the moment. But I can see that that's how HMRC might regulate it.
Thank you both. Next question. As a director, there are statutory duties one must comply by, one of which is active promotion of the company. What is the situation with furloughing?
In relation to, as my understanding, statutory duties, they are just limited to duties such as filing documents with Companies House, and there isn't much guidance given at this stage, as I understand, by HMRC concerning what the range of those statutory duties are from a furlough perspective. But I expect that there will be more information that will come out on this as well.
Thank you, Neelam. I've got one more question here. There's two questions within one. I just wanted to make sure everyone can hear. If you can you just type yes for me in the chat box, please? Perfect, great. Okay. So someone has said, if they have 6 employees doing the same work, but only enough work for 3 of them, can they rotate who at a time? And also, they've asked, can employees be required to take annual leave whilst on furlough?
Okay. Yes, you can rotate your staff. So if they wanted to rotate it three at a time, 3 weeks at a time, that's fine. The only thing I'd just say as a caution now is if it's something that you're looking to do now, we are roughly 6 weeks away from the end of 31st of May, and all we know at the moment in time that's when the government are saying that the scheme is at the moment eligible to. So it's just making sure that your timings around that 3-week rotation as a minimum coincides with that, because anything less than 3 weeks, then they wouldn't be eligible for furlough. In respect to the annual leave, I would probably say the only thing to consider that is at the moment we don't know the full guidance around that. If you do take annual leave, whether you can reclaim that back at 80% or not. And again, that may be a bit of a change to terms and conditions as well. But as Neelam kind of alluded to, there is no scope for annual leave to kind of be carried over over a 2-year period. So it may be something that you might want to consider as well. But I don't know if Neelam, you want to add further to
that. With annual leave, you've got to give double amount of notice. That's one of the things that you've got to do. So let's say, for example, if you want your staff to take annual leave, let's say 5 days, you've got to give them 10 days notice to do that. So that's part of the working time regulations. Number two, what is the rate that somebody's paid in terms of annual leave? There's a lot of debate around this at this moment in time because simply there isn't guidance issued on this. The inference from the HMRC, the government, is that if you are on annual leave during your furlough period, you get the furlough amount, the 80% or capped at 2,500. But then there is a different view on this as well, because in furlough period, you accrue your normal statutory rights, annual leave, sick pay. So the inference is that you would go back to the position, the default position of what is in your contract, and therefore your annual leave is paid at 100%. A lot of debate around this particular topic about the rates of pay, but I expect when HMRC set up the portal, things will be a bit more clearer about what you would pay, whether it's 80% or whether it's 100%.
Thank you. I'm going to take one more question and just going to let all the attendees know that we have taken note of all the questions and we will pass them on to Omar and Neelam for them to be able to come back to you. But one last question then I've had is, what if they've already got leave booked? Can they be on furlough and not allow them to cancel their leave? ACAS seem to suggest no, but my partner's employer says yes. So what would be the right thing to do here?
It's a good question. And again, it's about guidance as well, because we are working off lawyers as well. We're working off guidance available on the government website. This is my opinion, is that if you are on furlough leave, you are on furlough leave. It's not annual leave. So I would expect that if somebody's been put on furlough leave, they would be on that, and the annual leave would be deferred at a later time because this is the leave period that they're on. For example, when you look at the analysis of sick pay, so if you're on furlough leave and then you go on to sick pay, you drop onto sick pay and the rates that are available there. I don't know if Omar's got anything more to add to that, but I think that we would probably need to see more guidance about what would happen in this kind of scenario from the government.
Yeah, no, I echo that. I think with the annual leave, again, you got to remember is whilst they're on furlough, they can't do no work at all. There's that is that actual necessity to be on furlough. When you start putting them on annual leave, then the rules change a little bit. There's a little bit more flexibility on what they can do. But I think the biggest thing to consider is, again, what rate is. It's all going to be about the rate. At the moment, the guidance doesn't state whether that's at 80%, 100%, or anything like that. So for me, it's a bit of a common sense approach, which is just have that discussion with your employee. Outline, look, these are the benefits. This is the way to do it. You've, as a business, I've got 2 years to kind of cram that in afterwards as well. So just have that sort of conversation with your employee as well.
Thank you both. So thank you to all the attendees for joining us. You can still see on the screen Omar's and Neelam's contact details. So by all means, please do contact them. Also, as the Greater Birmingham Chamber of Commerce, we are here to support all our members and businesses as well. If you do need to get in touch with any one of us, I'd like to give you my email address. Please do take that down and do email me. It is a.con@birmingham-chamber.com. And as I've already mentioned, any questions that we've not been able to get through today, we will come back to you. Please do keep an eye on our website as well for our upcoming online webinars as well that we have, and do take care of yourself. So thank you. Thank you, Neelam. Thank you, Omar.
Thank you.
Thank you. Bye.